Hello, everybody. Welcome to another edition of The Productive Attorney. My name's Jim Zeta. I'm your host. The idea behind this podcast is to make you, as an attorney, more productive so that you can do the things that you enjoy in life that are outside the practice of law. And I'm hopeful if you're not an attorney or listen to this, you may get some information that can just help you on the day-to-day parts of your life. Today, we're going to talk about something near and dear to my heart, and that is the Texas Supreme Court. The Texas Supreme Court is the jurisdiction in which I practice. And as most of you know, I tell war stories at the beginning that relate to the topic that we talk about. And in this particular case, I do have a war story about the Texas Supreme Court. In my practice, I've represented defendants and I've represented plaintiffs throughout my 32 years of practicing law. I've watched the Texas Supreme Court during that time change from a Democrat Texas Supreme Court to a Republican Texas Supreme Court. And with that, when it was a Democrat Supreme Court back in the 80s and 90s, the decisions typically favored the plaintiff or the injured party. The last Democrat served on the Texas Supreme Court in 1998. It has been Republican strictly since then, and you have seen the decisions now swing greatly in the favor of defendants, which would be your insurance companies and your big businesses. Not so ironically, my practice has been the exact opposite. In the early parts of my practice, I represented defendants, sometimes insurance companies, sometimes big business. And then in the later part of my practice, I've represented injured parties. So I've been on the opposite side of the Texas Supreme Court decisions pretty much my whole practice, which hasn't been fun, but that's kind of the way it's been. I had not appeared in front of the Texas Supreme Court and had not had a case in front of them for most of my career. Mainly, I've had some Court of Appeals cases that I've written the briefs on, but the Texas Supreme Court had never accepted a petition in a case in which I had been involved. In order for the Texas Supreme Court to hear your case, one of the ways to get up there, and the primary way, is to file a petition for review. And the Texas Supreme Court does not accept very many of those, sometimes as low as 5%. So you may have petitions for review filed in your cases, but it's not very often that they're accepted. And so I've never had that until one particular case, and that's the case I want to talk about. There was a case that was referred to me back in like in 2010s, 2011, 2012. And it was referred to me by an attorney, and there was an individual who had drowned at the Trinity River. The Trinity River runs through Fort Worth, Texas. And on the Trinity River, it's a recreational place. It's got parks. It's a wonderful addition to the city. It's run by a group called the Trinity Regional Water District, which is a governmental entity, otherwise known as TRWD. And TRWD has constructed a series of 4 low-water dams across one part of the Trinity River near downtown. And those dams, in most instances, 3 of them have a canoe chute that's about 10 feet wide through the middle of the dam that allows water to go through. These low water dams have stairs leading down to them, have ramps leading down to them on both sides of the river. And on a nice day, if you go out, you will tend to find people walking on those low water dams. And when the water is low, and as it can get hot in Texas, sometimes the water doesn't even flow through those canoe chutes. It's just completely stopped by the low water dam. So I was contacted by somebody who gave me the file pretty late, meaning it had happened quite in the past. And I noticed in the file that TRWD had not been given notice. And under Texas law, you have to give 6 months notice, or else you cannot sue a governmental entity. And so I knew that we were going uphill, but I still wanted to make a point, because in my research I'd found that several people had drowned or nearly drowned at this one location, and I wanted TRWD to be aware of it. I wanted them to do something about it. We had a hearing on their motion to dismiss the case, and during the hearing, representatives from TRWD were there, and I strictly remember turning and looking at them and saying, "You've got a problem here. Fix the problem." The judge is probably going to rule against me, but fix the problem. And the judge did rule against me. We went ahead and I just went on with my life. But shortly after the judge ruled against me, I was at the dinner table and reading the newspaper, and I saw that another person had drowned at this location. So I had the information of all the previous drownings, and I let it be known to my network that if anybody had another case, that I would be interested in helping. And sure enough, about a year later, another person drowned, and that lawyer contacted me and asked me to handle that particular case. This case it happened in 2013. Prior to 2013, 7 people had drowned or nearly drowned at that location in the previous 7 years at this one location. And so TRWD was aware of it. They had put no signage up. They had done nothing to prevent it. They had given interviews on TV prior to the case of my young lady dying, that they were aware of it and they were looking at the problem and thinking about what they could do to fix the problem, but they never did anything about it. And so when the case came to me in 2013, I understood that I had an uphill battle. I had an uphill battle because under Texas law, governmental entities like TRWD are assumed to be immune from liability, meaning you can't sue them. But if they fall under the Texas Tort Claims Act, that's an act that the government put together, then you can sue them. So your case has to fall under this act. One of the problems, though, with the act is it says that if a decision by a governmental entity is discretionary, then they're not responsible for it, which is a huge loophole. The law is if it's about maintenance, then they can be held liable, but design and discretionary decisions, they cannot be held liable. And so if you've got, there's a case where they built a staircase and that staircase was not well lit, and someone fell, they'd be responsible if the staircase was not well lit because someone hadn't maintained the lights. But the government entity would not be responsible if the design or the discretion or the way that the stairway had been designed or built was improper. They would not be held liable. Weird, and governmental immunity law is weird anyways, but that was the law. So in my case, the facts were that Brandy Johnson is 19 years old. She was getting her life together. She was on her way to a job interview. It was a cold day. It was about 39 degrees. She had on a coat, jeans, Ugg boots, and the bus that she was taking to this interview dropped her off at a place that was across the river from where she needed to go. And so she was walking to her job interview. It was 12:59. Her job interview was at 1 o'clock as she came upon this low water dam. This low water dam, if you went across it, right across was the building where she needed to be. For her to go to a place that didn't have a low water dam, she would have to go a half mile either way down the river, cross the bridge, and come back across. I can just picture Randy. She's cold, she's going to a job interview, she sees stairway leading down there, and as you go down to the low water dam, there's no signs saying, danger or anything like that. And she comes up down the staircase, comes across the low water dam, and here's the canoe chute. And on this particular day, it's about 6 inches of water running through it. It is like glass. It is clear. And so she figures that she can just simply walk across it and get to her job interview. Unbeknownst to her, that 6 inch of water is going at a very high rate of speed, and the canoe chute is very slippery by design because they want canoes to slip through it. She slipped. She fell. And her screams were heard by 2 people from the building that she was actually going to do the job interview in, who saw her stuck just by the dam and her head bobbing up and down. They ran downstairs. By the time they got outside, she was gone. The Fort Fire Department came out and pulled her body out about 100 yards down from the dam. During discovery in the case, I got the case, I filed lawsuit, and during discovery, we determined that in the maintenance of the dam, when it was rebuilt, the TRWD had thrown in some like excess construction materials at the base of the dam. That in fact the dam was designed to only be 3 feet deep at that location, but in fact it had come up to being 8 feet deep. And so if it was 3 feet, the testimony in the case was that Brandy should have been able to stand up. But because it was this loose construction stuff, it had been slowly churned out at the base of the dam, and so much so that it had created a small island of all this construction material that was actually an island outside of the water downstream from this. So it was my argument that they hadn't maintained it properly, that they had set this up to happen. In addition, the hole at the base of the dam created a boil effect or a whirlpool effect that trapped people. And I had testimony from a young lady who, in a previous case, said that she had saved somebody, but said that she was an expert swimmer, and even for her, the undertow, the boil, the whirlpool effect was almost pulled her in. So there was a death trap. Brandy fell into a death trap, and during the autopsy, it was determined that Brandy was 5 months pregnant. Tragic. To Brandy's parents' credit, and they are amazing people, they went out and talked to TRWD and told TRWD, look, you got to do something about this. And TRWD put up signs, and the lawsuit helped. They put signage up. They put signs that survive when the rain comes over, the water comes over the dam. These signs still hold up. Put a lot of signs out there. And you can go, if you go out there, it's a big difference. So we went ahead and filed lawsuit. And we were at the district court here in Fort Worth, and that court ruled in our favor and said that we could proceed against TRWD. We had proven that they knew about it. We had proven that it was a dangerous condition. They were just simply arguing they could do what they want. It was discretionary, their decision. They wanted to create a death trap, they could create it. They didn't say that last part. Of course, I made that. I'm biased on this one, obviously. And then we won at the trial court. So, and I wrote all the briefs and argued it. And we went up to Court of Appeals, and I wrote all the briefs and I argued it. And we won at the Court of Appeals. TRWD predictably asked the Texas Supreme Court to hear the case. So I was hopeful that our case wouldn't be one of the 5% that would be chosen, but I wasn't optimistic. And I told our clients that I wasn't optimistic. I wrote a good brief, but I thought the Supreme Court would take a look, and sure enough, they did. And when the Texas Supreme Court accepted the petition, granted the petition, I knew we lost. No matter what I could do at that point, I knew we would lost. Why do I know we'd lost? Because of the outcome-oriented court that we currently have, where 80 to 90% of the time you have a plaintiff going up, you're going to lose. I wrote a brief. I worked very hard on the brief, and I thought that I would pull out every stop, and I brought in Jason Smith, a local attorney who has extensive Supreme Court and appellate background to argue. He argued brilliantly in front of the Texas Supreme Court, but predictably, the Texas Supreme Court came out and ruled 9-0 against us, saying that it was a discretionary function of TRWD, and we lose. I will say that the power of a lawsuit and the power of people making a big deal out of it does make a difference. Since the signage has been put up, no one has drowned at that location. People now are aware of the dangers, and they turn around and they go back. And so I would like to think that Brandy's parents, that their work, their efforts, and a little bit from the lawsuit have saved another 7 or 8 or 9 families from going through what they had to go through. So that's my war story on the Texas Supreme Court, but I also want to tell you some other cases and what they're doing. I want to talk about a case that came out last year called Amazon versus Macmillan. So my question to you as someone out there is, does Amazon sell products? And the answer is obviously yes. Amazon sells products. It doesn't take a rocket scientist to know that. Jeff Bezos is one of the richest people in the world. He didn't get rich off of just having a little marketplace. They sell products. And so the facts in Amazon versus Macmillan is there was a 19-month-old baby. That baby opened a remote battery compartment of a remote control, got in, and there was a button battery. The baby predictably swallowed it. The battery got caught in the esophagus. The fluid from the battery burned through the esophagus, causing permanent injuries to the baby. Under Texas law, a manufacturer and a seller of a product are strictly liable for the dangers of an unreasonably dangerous product. So in the questions in this case is the product unreasonably dangerous? But before you get to that question, you have to focus on the manufacturer and seller. Are they a manufacturer and are they a seller? Well, in this case, the manufacturer was a small company in China that was not subject to the jurisdiction of Texas courts. So you're going to have to go after the seller of the product, who in this case was Amazon. Amazon took it up to the United States Fifth Circuit Court of Appeals. That's the federal court of appeals. And so what does this have to do with the Texas Supreme Court? Well, on occasion, the United States Fifth Circuit Court of Appeals will say, look, we can't answer this question. We don't know enough about Texas law to answer this question. We want the Texas Supreme Court to answer the question for us. And they sent a certified question to the Texas Supreme Court that said as follows: under Texas products liability law, is Amazon a seller of third-party products sold on Amazon's website when Amazon does not hold title to the product but controls the process of the transaction and delivery through Amazon's Fulfillment by Amazon program? And that was the question that was sent to the Texas Supreme Court. And so I teach advanced torts. This case was last spring, 2021. Because of COVID, the arguments were on Zoom. So I had my students watch the arguments, and I asked them on their final exam, what do you think? Is Amazon a seller as under the law? The majority of the students wrote that they believed that Amazon was a seller under the law, just by common sense and also by the law. I then asked them, what do you think the Texas Supreme Court would do? And by giving them a healthy sense of cynicism, by having them look at some other decisions that we might talk about a little bit later, majority of the students said they felt that the court would find in favor of Amazon. Because they find in favor of the defendants or the corporations or the insurance companies 85 to 90% of the time. After the final exam was done and graded, the Texas Supreme Court came out with their decision and predictably found that Amazon is not a seller of products. They went on for 20 pages about title and made all these little hyper distinctions and came up with their decision. I mean, you can go and if you listen to this podcast, you can tell your friends that Amazon does not sell products according to the Texas Supreme Court. I know it's a little more technical than that. I know I am biased just by the TRWD decision, and so you have to take my comments with that grain of salt. But I think that's a kind of an absurd result that you get with an outcome-oriented court. Another area of the law that I want to talk about that the Texas Supreme Court dealt with is medical malpractice. So in September of 2003, the Texas legislature changed the medical malpractice laws. And the reason they changed it was because there was supposedly a crisis of doctors leaving because they were getting sued so much. And the voters of Texas allowed the legislature to do this in a vote. There was a proposition, and it carried 51 to 49, hotly contested, but did give the legislature authority, so the people allowed this to happen. And what the legislature did was said that in order to file a malpractice suit in Texas, we are going to require the plaintiff's attorney to file an affidavit from a physician practicing in the same area who says that what the physician did was malpractice, that the physician breached the standard of care. Now, that one requirement is very difficult for lawyers, because what it requires a plaintiff attorney to do in every case is get the medical records and send them out to a doctor and have the doctor look at it. That's expensive. Getting the medical records is difficult, but getting a doctor to review it and give an opinion who practices in that same area is very difficult and very costly. And so you can run up, as a plaintiff's attorney, you can run up between $10,000 and $25,000 getting that opinion. But in many cases, the opinion that you get is, no, it wasn't malpractice. So in order for plaintiff's attorneys to maintain a medical malpractice case and to take these cases, they have to review 10, 100 cases, and they should pick out the ones where the malpractice is clear. But now they're spending hundreds of thousands of dollars evaluating cases, and the legislature said, okay, what we're going to also do is say that non-economic damages, so pain and suffering, mental anguish, are limited to $250,000. So now the plaintiff's attorney is in this situation where they're capped on the amount of damages they can get, and they're capped, and they have to spend all this money to evaluate the cases. And very well done by the legislature in terms of lowering the lawsuits, because here in Tarrant County, as an example, in 2004, there were 90% less malpractice cases filed. And currently, it is hard to find a medical malpractice lawyer in Tarrant County or anywhere in Texas. Most of them, those lawyers who do that kind of on the side. My view of malpractice is, in order to take the case, is the patient dead or maimed, and can you explain it to me in 30 seconds or less? If those two requirements aren't fulfilled, it's probably don't have a case under Texas, which leaves a lot of cases, terrible cases, open. We had a case where a dentist dropped a drill in a client's mouth. That drill just it probably seemed like forever, but for a short period of time, just bounced all around that mouth, cut it all up, chipped teeth all over the place. Not enough. It was clear malpractice and negligence, but not enough. And so why am I bringing up the Texas Supreme Court when we're talking about malpractice? Well, that when you have it's human nature that when you have an advantage, you take advantage of it. And so the defense bar said, hey, if we can take this medical malpractice and all these expert requirements and all these caps, maybe we can expand this, further. How can we expand it further besides doctors and patients? Well, it didn't make sense, right? I mean, it was malpractice, doctor-patient relationship. Well, the term healthcare liability claim is the term that's used for these malpractice lawsuits under the law. And in 2012, the Texas Supreme Court was faced with a case under Texas West Oaks Hospital versus Williams. Mr. Williams was an employee of the hospital. He was put in an unsupervised area with a patient who was a psychiatric patient. There was a scuffle that ensued. The psychiatric patient actually died, but Mr. Williams, the employee, was injured. Mr. Williams sued the hospital, saying, you shouldn't have put me as a technician in this dangerous position, right? Is that medical malpractice? No, there's no physician-patient relationship between Mr. Williams, who's an employee, and his employer, the hospital. Now, under Texas law, the hospital in this case was a non-subscriber, which means that they weren't subject to workers' compensation insurance, which means they could be sued. So Mr. Williams properly sued the hospital. And the Texas Supreme Court heard this decision on whether or not it was a healthcare liability claim. It doesn't make any sense that would be a healthcare liability claim. There is no medical malpractice. Mr. Williams was not a patient. Mr. Williams was an employee of the hospital. But guess what? Texas Supreme Court held that was a medical malpractice claim. It was a healthcare liability claim. And because Mr. Williams did not file an expert report, by the way, what expert report would you file in that case? I have no idea. But because he was not and did not file a proper expert report, he lost the case. And not only lost the case, but under the law, that when you lose a case for failing to file an expert report, you have to pay the hospital or the defendant's attorney's fees. You're required to pay their attorney's fees. So the case got sent back to district court for the court to determine how much money does Mr. Williams owe the hospital for suing them. That's what the decision was, Texas West Oaks. I sincerely in 2012 remember reading that and could not believe it, and was wondering where the chatter was going to start to come up. And I didn't see any in all my listservs and all the stuff that I was thinking about. And I said, man, people just aren't paying attention. And they weren't. And so predictably, the Texas Supreme Court has taken Texas West Oaks and expanded the definition of healthcare liability claim. In 2019, there was a case in which a nurse fraudulently recorded information on a patient's medical records. I don't know what that has to do with the doctor-patient or medical malpractice, but that was a healthcare liability claim. In 2020, the Texas Supreme Court decided a case in which an Ohio bridal shop sued a hospital because a nurse at the hospital, this is a Dallas hospital, had a nurse at the hospital who was exposed to Ebola. This nurse then traveled up to the Ohio bridal shop and was in the bridal shop. The bridal shop had to shut down, and because they had to shut down, they eventually went out of business. And they sued the hospital saying, you negligently allowed this nurse to be exposed to Ebola, and therefore you caused damages to my bridal shop. And the Texas Supreme Court said, Ohio bridal shop, you lose. That's a healthcare liability claim. We remand it back to the district court to determine how much money you owe the hospital in attorney's fees for wrongfully suing them. In 2021, there was a mental health facility where a patient died, and they say, well, the mental health facility is a healthcare liability claim. 2022, we just had a decision come out. A young lady went in for a face peel at a spa. Dermabrasion face peel. It was negligently done. She sued the spa for damage to her face. Guess what? That's a healthcare liability claim. Because she did not file a expert report, the Supreme Court reversed the case, sent it back to the district court to tell that lady how much she owed the spa in attorney's fees. And in those cases, the attorney's fees are significant. Usually 6 figures by the time it gets to Texas Supreme Court. Finally, I want to talk about one other case called the Brainerd Case, which was decided in 2006. If you don't really get any tips out of this other than this particular one, this is one I want you to have, and that is, if you have the ability yourself to get uninsured motorist coverage, that is when you have a automobile accident and the other party does not have insurance. I highly, highly, highly recommend that you buy uninsured motorist coverage. I hear from clients time and time again, I have liability insurance. Liability insurance means if they sue you, then you have coverage, right? And so if you cause the accident and they sue you, you have coverage. Well, I will tell you, 50% of the people in Texas, if someone sued them and got a judgment against them, the other side couldn't even recover because there's so many exemptions under Texas law. Your house is exempt, your car is exempt, your IRS retirement policies are exempt. Liability insurance is not that important. What is important is if the motorist that hit you was responsible and they did not have insurance. That happens much, much more often. And so you want to buy the uninsured motorist coverage. So you would think that suing the other party when the other party was at fault and they had insurance and getting that other insurance company would be more difficult than asking your own company after you've been hit by an uninsured motorist to pay for that coverage that you bought. So, hey, Mr. Insurance Company, I bought this uninsured motorist coverage. This person didn't have insurance. I've got $30,000 in medical expenses. Will you please pay those? What has happened is, because of a Texas Supreme Court decision, that case, the case of you going to your insurance company and say, please, Mr. Insurance Company, pay my uninsured motorist coverage, that now has turned into a nightmare. And here's why. In 2006, the Texas Supreme Court decided a case called Brainerd versus Trinity Universal Insurance Company. I call it Stupid Brainerd. It's got the word brain in it, and I call it stupid, which is ironic. I don't know why I think that's funny, but I call it Stupid Brainerd. Brainerd said that in an uninsured motorist coverage claim, that the insurance company does not have to pay the claim that you make against them, your own insurance company. They don't have to pay it until you are legally entitled to recover. And so how are you legally entitled to recover? Well, the way that you're legally entitled to recover is you have to sue the uninsured motorist coverage, or you have to sue the uninsured motorist. So the person that hit you, who has no insurance, don't know where they are, and was clearly at fault, the insurance company, the Supreme Court decision now says you have to go out and sue that person, hire a lawyer, sue that person, get a judgment. And then, and only then, is the insurance company have to look and see whether or not they're responsible to pay under that policy. So what happened in real life, practically speaking, was that when we as plaintiffs' lawyers would ask an insurance company to pay the uninsured motorist coverage, they would say, you don't have a judgment against the other side. You have to go out and file suit and get a judgment against them first. So we had to go through a 12 to 18 month, sometimes 24-month process to get a court to rule that the uninsured motorist owed that particular money. Then and only then would the insurance company be responsible. And then and only then they'd only be responsible for the insurance policy limits, which in some cases were as low as $30,000. That's the minimum in Texas. So you could have a person a client who got hit by an uninsured motorist, have $100,000 in medical expenses. You can ask your own carrier to pay those medical expenses and to pay that claim, and they would look at you and say, you don't have a judgment against the other side. Even in cases where the other side was clearly responsible, they would make you jump through those hoops, and then when you came to them with a judgment for $100,000 and asked them to pay, they would send you a check for $30,000. And the insurance company would use the Brainerd decision and hammer plaintiffs' attorneys again and again and again. The problem that we ran into as plaintiffs' attorneys is, if that case is right, Brainerd is correct, then the insurance company, who has their policy as a contract, they haven't breached their contract. The insurance company is not required to pay until you're legally entitled to recover. So what's up with the insurance company? They haven't breached the contract. How do you sue them for what they did wrong? How do you put pressure on them for what they did wrong? What is your claim against them? And that's what the Texas Supreme Court was finally faced with in 2021. The case came up in front of the Texas Supreme Court, and there had been 15 years of case law where plaintiffs' lawyers have been banging their head against the wall trying to figure out how they can force insurance companies to pay. And the Texas Supreme Court, to their credit, asked the lawyer for the defendant, what is the cause of action? We have ruled that there is an obligation between the insured, meaning the person who has the insurance, and the carrier, the one with the uninsured motorist coverage. But what's the cause of action? We've said they can sue you, but what is the cause of action? And the insurance lawyer had no answer to it. And so the Texas Supreme Court had to come down with the decision. And the answer is something called the Declaratory Judgment Action, which means that the court can declare the rights between the parties. But the one big kicker on that decision is that a declaratory judgment action allows a plaintiff's attorney to get attorney's fees for bringing the case. Now the plaintiff's attorneys finally have a hammer. And that is, hey, insurance company, we're going to sue you for declaratory judgment, and we're going to rack up some attorney's fees. So not only are you going to owe the $30,000 at the end, but you're going to owe all our attorney's fees. We finally have something to say to the insurance company to try and get them to go ahead and pay these UIM cases, uninsured motorists or underinsured motorist claims. But it took 15 years. It took 15 years to get that, and it still isn't completely fixed. There has been efforts at the Texas legislature to get this fixed, but and the House, Texas House, has looked at it favorably, but the Texas Senate, which is, in my opinion, controlled by special interests, they're never going to look at this. They're never going to fix the Brainerd decision. So this is what we've got with right now. Finally, the last point I would make is the Republicans are wanting to. And I'm not Republican or Democrat. I'm just telling you from one side or the other. But the Republicans have the huge advantage right now in Texas, and they're struggling because in Texas there are 14 courts of appeals, and right now 7 of them are controlled by Democrats and 7 of them are controlled by Republicans. And since the Texas Supreme Court only hears 5% of the cases that come up to it, there's some decisions that are happening in some of the Democrat-controlled courts of appeals that these Republicans and big business and insurance companies don't like. They're upholding some jury verdicts and that are bigger jury verdicts requiring some of these big businesses to pay a lot of money, and they don't like that. And so what's their answer? Well, their answer was, in the last legislative session, 2021, is to gerrymander the Court of Appeals districts. And so they were going to reduce the Courts of Appeals districts from 14 down to 7. And of those 7 Courts of Appeals districts, only 2 would be Democrat-controlled. That way, the Texas Supreme Court could take up any decisions from those 2 Courts of Appeals, and the other 5 could control the verdicts that way. That had not passed. There was discussions on it. There were hearings on it. But it will be revisited when we come up to the legislature here in 2023. Look at that as the next step of trying to get the control of the courts here in the state of Texas. So that's my story on Texas Supreme Court. I hope you enjoyed it, and I'll talk to you next time. Thank you.